That's all they could say.
Oh, really?
Oh. So,
I got a
so
friend
hard
in
to
the mom.
imagine that.
He's getting 90 years old.
Yeah.
Yeah.
They would still do that, they have their.
He's been a diehard Democrat for 30 plus years.
All right. Okay. I'm going to call the meeting to order at 6 o'clock. Have everyone rise and for the Pledge of Allegiance. Pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, Alicia, can you roll call, please?
Yep. Steve Digaloff.
Here.
Ian McDonald.
Here.
Lori Belarden.
Here.
Lacey Oster.
Here.
Bruce Belarden.
Here.
Danny Erickson.
Here.
Matt Kukal.
Here. All right, our district mission, together we engage, educate, and empower all learners, bridging their passions and pathways to create successful futures and positively contribute to our local and global communities. I'll take a motion for approval of the agenda.
So moved.
Is there a second?
I just want to make a quick comment on the agenda. There's no public comment. There was a lot of people spoke out about not having public comment. I just want to remind everybody here that this is really just an extension of last week's meeting. There's no action being taken. That's the only reason I supported not having public comment, because there's nothing new on this. We heard it last week. We're here again next week, and I encourage anyone that wants to speak, please come, because there will be public comment. So
I would,
Are you seconding that?
and I'll second that. Yeah.
Steve, yeah.
Well, I was just gonna say we should reverse the order of the policies. I don't know if we're going in the order that's on the agenda,
No,
but
it's mine.
the hot topic button are the last two policies. People can't, they can't speak tonight, but at least we can address these and get them handled.
I would agree with
Up
that.
here, if you guys want to connect. I'll move them over, and if we can move it, maybe move that one.
You want a
We're gonna amend that motion then?
Does anybody want to make an amendment to move these other policies to the beginning?
I really like this.
So you just want to change the order?
Is this your stuff? Can we
So
move it over by you?
I'll
Just if we have another chair.
amend my motion so that the order of the policies is as submitted on the agenda, with the exception of policy 2264 being moved to the top. 2266 wasn't doing anything with, it was simply there for information.
I'll second that.
Okay, all those in favor?
Aye.
Any opposed? All right. Okay, then, I guess we will start with 2264.
Does anyone know what page that is on this PDF, by chance? Where it starts?
26.
Oh,
25?
yes, it is.
Thank you.
I'd like to open up a discussion. I wasn't here last week, so I did review the video of last week's meeting, and a lot of things bothered me about that meeting, in that we've got an attorney giving us advice that isn't accurate.
I was right. Yeah.
Okay,
We were
so,
right.
okay, and I want to do this again. Last week, this is a public meeting, this is not an open meeting. So a public meeting means that the board will be discussing, and the audience can sit and listen. And get a few comments, we can talk about them after or before the meeting, but not during the meeting, because we need to do the work of the board during this meeting. So please refrain from speaking up during the meeting.
So I'm going to speak to the men on the board, and yes, I'm referencing men and women here tonight. Men on the board, as dads, it's our job to protect our children. And we need, can I continue? Are you going to cut me off?
Well, so what we're doing tonight is going through the policies.
We are going to go through the policies.
So that's, we're gonna start with 2264, which is policy. And that's what's on the agenda tonight, not to go through what we talked about last meeting. We're gonna go through the
This is a
policy.
continuation of the last meeting, so I can speak.
But we're talking about
Are you
policy.
going to let me speak, Bruce?
if it pertains to this policy,
It
and what we're
pertains
going
to
and
the
reviewing
policy.
the policy.
Pertains to the policy. We're talking about
What-
1,500 pages.
What section of the policy?
Bruce,
is what you're
1,500
saying?
pages is what the new Title IX revision is. We started off with one paragraph, all right? So that tells you something, that it's not constitutional when you take wordsmith, a lot of different things, there's a lot of components here. We owe it to the public to discuss this, and I have a few things I want to say, all right?
Are you speaking just to the men on the board, or are you speaking to the entire board?
I'm speaking to the men on the board, and then I'm gonna speak to the rest of the board. But I'm just saying, men, we need to do the right thing, okay? It's our job to protect our girls, and that's what we need to do, okay? So, I moved to this town 3 years ago, all right? I believed that this town, being a smaller town, moving from the Twin Cities, would reflect the values of its citizens and its taxpayers, its parents. And unfortunately, after 3 years, I see that it feels like the administration is running towards DEI, woke agendas, including a rush to embrace the new Title IX revision. Like I said, 1,500 pages, where it puts girls in jeopardy. They will not be safe if we acknowledge this and go forth and put and implement new policies. It's unbelievable that we're discussing this. We could put this on ice, and I will say right now, we have an injunction. If we vote for new policies, we are going against a federal injunction. We have students whose parents are members of Moms for Liberty. Moms for Liberty is named in this injunction in Kansas. I believe everyone was sent a 47-page ruling from Kansas that specifically states Moms for Liberty. Each school is protected. This is an injunction. Why we're even talking about this, I don't know. I'm going to go on here a little bit. You know, as a newcomer, I decided to run for school board. Everybody told me you're not going to get voted in, but I listened to our parents, our taxpayers, and I had a strong message that was for parental rights and for student safety. And here we are talking about things, we're getting distracted. We've got a budget where our administrator's talking about going over deficit spending. We still, after 3 meetings, don't have a plan for long-term SRO. Still haven't gotten that accomplished. And here we are spinning our wheels talking about something that is not applicable at this point in time. We've got an injunction. We need to move forward, talk about the other policies, and rescind any of this discussion, any policies 2264 that are in place. Look at rescinding those. Excuse me, 2266, 2264. We should eliminate that from discussion and be done with it. That's all I got to say.
Okay, I'll start with the beginning of this policy then. So we have our first line pulled up. So I guess just as we go through, we didn't get very far to the policy committee. So I think one of the first checks was checking off policy 266 is the end of the option. This policy will take effect on August 1st of 2024. Just continue down the page. I guess, is there any questions as we move down this document? If anybody, so everyone should have taken, sort of looked at this and reviewed it. If anybody has questions on any items of this. Otherwise, one of the first things that I noticed that was different from what we currently have, which is on 2266, is that the update in this is at the top of page 3. Alicia?
On this doc?
Yep.
Page 3?
Or not 3, sorry. Whatever it is, 27. So it should be down a little bit.
That's 28.
Keep going up. There you go. So that discrimination, so it says discrimination on the basis of sex includes discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. our previous policy included sexual orientation and gender identity. This new one includes sex stereotypes, sex characteristics, and pregnancy-related conditions. So by adding this policy, you're keeping the words that we already had in the old one, but adding sex stereotypes and characteristics to be also discriminated against.
And pregnancy or related
And
conditions.
pregnancy-related conditions weren't included in the other one. So sex stereotypes,
So that was that last revised in 2022 with those, with that verbiage, gender identity, or do we know when that occurred?
sexual orientation, gender identity.
I believe
Oh,
it was
because of what it said
2010.
before I was.
Yeah, so those were on previously, and the added language for this one now is, so we won't discriminate against sex stereotypes or characteristics or pregnancy. So that's been added to this one. That's the only difference in that line, is that portion. Any questions on that?
Well, I wasn't on the board then, but I certainly wouldn't have approved gender identity based on case law. So whoever did that was.
We have a record of who voted for that, if there's any current members, I would imagine.
It's because it's not in state law, so. And it's being challenged in the courts right now, Doe versus Alcorn.
So gender identity is not in state law.
I believe we went through this at length
Well,
at our last meeting.
that
and
might be the case, but show me where it's in the law.
Trevor explained how, as cases are decided through the courts, that goes forward as,
Show me the case law.
Let's say it's been brought up, it shows the cases below that this has come up since, and this has been upheld. So, I don't know why we would not include something that has been upheld by other cases in the state of Wisconsin since this has been in place.
So,
So then are you also now stating you would like to pull this out of policy 2266 that we currently have in place?
that is correct. Both policies should not be in effect.
Okay, so, but then you are okay then with sex stereotypes or discrimination against stereotypes, characteristics, and pregnancy? Because that would not be included then, be covered by our school.
Do we have a problem with that now? Why are we explicitly having
Do we have a
policy?
problem with sexual orientation or gender identity
Do
being
we,
discriminated in our school?
do we have that problem? Dr. Donnelly, have you had any issues with this?
Issues with gender identity.
Right. in the
So
school.
I'm not comfortable speaking about that specifically because I don't want to inadvertently have any students or families identified.
Okay.
But I guess what I would say is that if this does come up, I would like anybody who is discriminated against because of their stereotype or characteristic or pregnancy, that they could come and bring a claim with Title IX. If we're talking about protecting our daughters, I
Okay.
specifically think pregnancy would be protecting our daughters, to make sure that,
people are not discriminated based on their pregnancy or related condition. This entire sentence is in the federal law. I am not comfortable with removing language. This isn't even, this particular sentence is not even an option for the school board to be addressing. This is in the law, and we pay Neola, the company that goes through our policies and keeps up with the law. They only give options where the school district has options to them to take. If it's a sentence like this one, this is in the law. This is not an option. You can't just take out pieces of the policy that are addressed in the law.
Policies are optional to the extent that they're needed. Now, when you bring up Neola, Neola's pushing this policy creation because they're going to gain monetarily from this. We're talking about training sessions that, who knows, maybe even board members will have to take.
Neola doesn't do any training.
Neola does, they advertise the training sessions.
Well, we don't have a contract with them for training. We have a contract with them to keep us up to date with the legal issues as related to our
All right,
policies.
that's understandable. So when we put a policy in effect in Title IX, you know, if we adopt these policies, then as far as training goes, who are we gonna go to for the training?
I'm gonna ask our administrators what they recommend.
Okay, well, I'm guessing that you all already want.
You can't make this.
Okay, we'll keep going down.
I just want to say, like, so the problem I have is, here's this policy in Title IX that's already in place, and this language. Steve, I'm in full agreement, like, protect our daughters. I have kids that go to this district. I'm 100% in agreement with you. But at the same time, I'm with Lori on, like, we are stuck. Now, this is a prime example of, here we are with a disaster on our hands, and like, what are we supposed to do? Other than get out and vote in a couple of months, like, I think like we could sit here all night and pick this thing apart. But we have a policy that's in place, the protections are there. I mean, I'm okay with saying, I think we need to hit the timeout on this whole thing. We got a policy, we have protections, people aren't discriminated against, we can fall back on it, but do we have to take the next step right now? And I don't know if we do.
We don't, because.
But I also,
we got an
hold on,
injunction.
let me
Okay, go ahead.
But I also I don't know if now is the right time to try to go back and start pulling language out. I think that takes us the wrong direction. And I think we can find common ground somewhere. And I guess that's what I hope.
We don't need the policy. And we have an injunction right now that is enforced.
I agree.
At the school.
I agree, but I think like to try to pick 2264 apart and try to change that language, I don't know if now is the right time for that. That's all I'm saying. Like, I think the language is in there, and I think some of us probably look at it and go, wow, like, where did that come from? I don't agree with it. Or I do agree with it. It's there. It's there. Protections are in place. But to sit here and try to go back, I think we need to decide, like, is this moving forward, or are we going to just maybe hit the timeout button and wait? Because there is an injunction. There is things taking place. Maybe that's the way to take a stance and say, we're going to protect our kids. At the same time, protect anybody else that feels discriminated against, because I think that's important.
So here's the one problem. So if somebody feels like they're discriminated against, let's say transgender student, they go to one person, right? Who is that?
It's listed in the policy.
Okay. So, I mean, you've read this, so who is it? It's,
Could be Abby, our Director of People Services.
okay.
Yep.
So you'd have one person making all these decisions. And, okay, so let's say that you got a student one day that's got a problem with another student, and here's how I get at them. I retaliate by saying the next day I'm transgender. After they've been punished, then I go back to, because it's all fluid, you know, this sexual identity thing, right?
Abby, could you speak to that? Would that be, I don't mean to put you on the spot, but like, what is the process that you would follow if that would occur?
When I receive a complaint, I have to put it against the definition and making sure that it actually meets the definition of harassment or discrimination or assault or anything like that. And then it is not just me, solely me. We have used myself, and then in prior, the ruling is a Title I person cannot be, or the coordinator, sorry, Title IX coordinator cannot be the investigator. So it's actually a different person doing the investigation, and we have the whole guidelines that we have to follow to meet those guidelines. And during that investigation, both parties are taken care of with supportive measures to make sure that I don't find people guilty, you know. We make sure that we're supporting both parties until we find out what happened, and then we come up with a result, and that goes to a decision maker. I am not the decision maker. I know that in the new policy, it says that it can be the one person having all those roles, but up till now, we have not practiced that. It's been a different different person making that decision.
And the same person, the language in the policy is that the same person may be,
Yeah.
but is not required to
Right.
be. So to make the statement that one person is in charge of the whole thing is not actually true.
And there is an appeal process
Yes.
too, if this doesn't go, or someone can appeal within, 5 days, I think is what's listed in here, to somebody else.
So this is basically DEI on steroids, is what this is. You've got an administrative agency working for President Biden, who's got half a brain, I'm sorry, but it's true, that's coming up with this. We don't even know who's behind it. It wasn't Congress. The legislative branch of government had nothing to do with it. And you go from one paragraph to 1,500 pages? It's unconstitutional, we all know it. This violates our daughters, our students' First Amendment rights. They can't even look at somebody sideways. They could be accused of misgendering them. This is
Okay,
ridiculous.
so there's definitions in here, and there's investigations that have to be done, that if you're saying it's this easy, I would say those investigations would prove out that that is not.
Listen, when it comes to investigations, we had a 60-day investigation last year that supposedly happened regarding a principal that was put on administrative
We're
leave.
talking about
I know we're
the
talking
agenda
about
item
this,
2264.
but here's the problem. These are not transparent. These are all swept
Okay,
under the
so
rug.
continuing through this item, I tried to just go through and compare these policies to find out what was different. So that if I'm gonna support this moving forward because of, state law, and this is what we're being suggested to impose going forward, I was trying to figure out, am I in support or against these? And by seeing these added language in there, and who is supported under being discriminated, that's what I was trying to outline. So things that we have in place and adding things going forward. That's the only reason I'm calling this out, and I agree we don't have to hit every item, but I really asked the board to compare these two, and before we just say we're gonna put everything on timeout and hold, because I think making sure that we add discrimination, so we aren't discriminating against added people or for added reasons is very important.
Aren't there already protections somewhere in our policy for pregnancy? How about just regular, and I don't know what I'm saying, employment law?
Of course.
Employment law, but this policy addresses not only employees, but it also addresses students.
So I guess one of the options going forward down this list was, one of the options was to remove confidential employees or check your confidential employees. Is anybody, it was struck, so I think that the board or the policy committee go through this one, that's ready to remove.
Yes.
So we took out confidential, that was a recommendation from you.
Yes.
Has anybody actually read the 47-page ruling from Kansas here, or are we just talking about this policy?
We're just talking about this.
We're talking about the policy.
Okay, well, I'm just asking. Is
Have you read
everybody-
the policy, Steve?
I have, so, you know what? 47 pages of an injunction that we have right now. Who has read that on this board right now? Good, I'm glad. We've got at least one. Okay, two.
But there was also, and Steve, I have read it, and I think there's some really important things to note in it, but there's also, that was with Kansas, and there was also that questioning, and we asked Trevor this specifically at the last meeting, and then how it relates specifically to Wisconsin.
It's a federal judge.
But that was one of the questions
Moms
that
for
I
Liberty is a
specifically
national
asked.
organization with many
I
thousands
get
of
that, yes,
students.
I
Okay?
completely, I read it. Am I able, I actually should, am I able to speak right now, or are you still
Absolutely,
talking to
go
the men
ahead.
of the
Go
board?
ahead.
Because I think that there, and I said this at the last meeting, and like, I think there's some things in there that are absolutely, we need to take note of. But when I specifically asked about that question, it was questioned because it was happening in Kansas and not ruled by the state of Wisconsin. Because that was, but then I also said, because we're waiting, there's so many things in limbo right now, that I'm kind of, as Matt had stated, there's a lot of things going on right now as far as making this decision by August 1st. I'm hesitant on that, due to all of these things that we're getting.
Why don't we just wait? Let's just move on.
We should make a motion just to delay
What?
this.
We aren't making
I would,
any
I think,
decisions.
I think I'm gonna speak for what you're gonna say. I think we should go through it and at least highlight what are the differences, because we're not deciding tonight anyways, and then next Monday we can decide, right? Like, at least let's just go through it and highlight the differences. We don't, again, like, we can go through this all night long, let's just at least get it all out there from what we have today to what is proposed for next week, and then next week we vote.
Well, and out of respect, I specifically, when we made the motion not to have public comment tonight, went back to say, I am comfortable with saying no public comment because we are not voting. We're not making any decisions tonight. That is next week. So I don't feel comfortable making a decision or making that motion due to exactly me being in favor of no public comment. I think that that's appropriate for our news meeting.
Okay.
Yeah. Let's go through it, highlight the differences, so we're all on the same
Okay.
page.
One of the things, I'll just highlight it so everyone can kind of go back and do some research between the two that I found, if anyone else found, any differences. Even just scrolling down through this, a lot of these definitions are the same. I think parental status is one that was added down about 7 pages or so into this document. And keep scrolling there, Alicia. Right there, so that, I think on top, that was kind of some added language, party, peer, pregnancy. Again, the thing I'll talk about is pregnancy was not in any portion of Title IX before. So it was not included in this, in our policy before. So anything relating to pregnancy has been added to 2264. Going to go through, there's some changes to, I think, the next page, I think hostile sex-based harassment, hostile environment harassment. There was some additional language added there. You just have to kind of compare the two.
The hostile, yeah, in the previous policy, it had to do with and. I'm not there, but I think you're talking about pervasive and, what was the word again that you said? I'm not on the right spot in that policy.
Pervasive and severe, and now
Yeah,
it's severe
or.
or pervasive.
Yeah, that's the difference.
Yes.
We went past it,
Okay.
where it describes what an education program or activity refers to. This is in both.
Yeah.
Refers to all the district's operations, including but not limited to in-person and online remote educational instruction, employment, extracurricular activities, athletics. It's in both.
Yeah, and I guess it was in the other one, so I didn't. That's it. But again, we've gone through, I think everyone's heard this policy does not pertain to athletics.
Well, why?
Sure does. That's, Title IX was based on athletics. Don't even go there. Trevor is misleading you.
The Department of Education, we got a policy perspective from WASB. Did you read that?
And WASB I don't trust.
Oh,
So,
Yeah, I trust the Kansas ruling, that's what I trust, because that's an actual judge.
oh my goodness.
What do you mean, oh my goodness? This is a federal judge. The federal judge is versed on federal laws, not state laws, okay? It happened, yes, in Kansas.
So even in the document I was sent today from Wisconsin Liberal, or not Liberal, Liberty, So Will sent out, and they even said in there, it doesn't pertain to sports. It doesn't pertain to athletics. Okay, that is a ruling that's coming later. So that's not in what we're discussing now. If athletics is added in later to sports and who can participate in a different sport, at that time our board will discuss it, but it is not in this. And I'll say it again, it is not what we are discussing.
Okay, what about the restrooms then?
So I would like you to tell me, Steve, in this policy 2264, where it defines anything about locker rooms, restrooms,
It says
anywhere
right-
in there.
I'm gonna answer for you. It says right here in the drafting notes, it's gonna have implications on locker rooms and bathrooms. It says it right there.
Where in the policy that we were adopting does it say that? So our policy that we're gonna have in place,
Well, I haven't made it all the way through yet, but it's in here.
Yikes.
the only part that talks about bathrooms is in the pregnancy section of this policy.
Why would they have that drafting note?
Bruce, if you want a separate policy for pregnancy, I'm sure we can figure
Yeah,
that out.
we can add
I don't
that
think we
to-
need to adopt.
I would like, I
this.
would like to know though, specifically, because I feel like that is the hot topic and the things, I mean, the signs, the girls in sports, boys in, like, that's, and in the document, there was an email that I received today specifically going through those will notes saying, as Bruce is saying, it's coming, and I think we need to be ready for that, but in this specific, it's not.
Why did the House pass a resolution this last week and all the Republicans were talking about sports?
I don't know.
So it's so vague, why not just shelve it? There's so much going on.
Exactly.
Well, and I'm just saying, because there are other things in here that are positive. This isn't completely negative. This is not, there's nothing wrong with that first paragraph where we're offering additional, where we're protecting additional stereotypes and characteristics from discrimination and pregnancy. I don't know. And this doesn't have any, this is not sports and this is not bathrooms. This policy, no matter what we do with this, it won't change sports or bathrooms.
If you really want a pregnancy policy, I'm sure we can find
Can we
one.
continue with this policy? You, I believe,
Yeah.
had gotten to which page?
It's gonna take hours to go through 80 pages when this could all be just reversed in 3 weeks.
So, I would say, I think pregnancy, again, that was something that was added. That whole section, which is multiple pages long. I think there's some options in there.
Yep.
So 12 pages in, Alicia, so page 38, 39 at the top.
So Bruce, you tapped into the other school districts. I'm sure Dr. Donnelly is as well. How many others are talking about this right now? Is Hudson?
Yes.
Okay, in their board meeting?
Yes.
New Richmond has a meeting tonight, I believe they're
Okay.
talking about it, every
Yes.
single,
Everybody else is talking about it as well.
Okay.
and I hope there's the same conversations, I mean, we're not out to, this isn't, I would rather go through this and we can keep going, but I don't wanna sit here and argue either, Steve. I think as we can continue, and yes, there's, I hope, as all of you are here, there's lots of other meetings going on too. We're not the only one.
So, yeah, it was, C policy 5751. I think we had to check an option for school-age parents, or school-age parents and married status of students in administrative guidelines, is what we checked. Or what? So also the document, Lori went through the Neola recommendations and put those in, so that's some of these as well that I have checked down here. Continuing through this, one of the conversations we wanted to talk about is, are we putting in a position, Shannon, or a person for this?
We'd rather the person, that way it's easier for people to immediately identify if they go to the policy, they don't have to take another step to go to the website.
So that'd be Abby Bahada, and then the second, I think there's an option for a second assistant Title IX coordinator. Is that something we've
Instead
also
of a
included?
second, yeah, I read through all the Neola recommendations. And so Abby, that's one of the things I wanted to get from you. When I went through this, based on the Neola recommendations, I was thinking going with the title, just one person being the coordinator and you being that person. They also recommended a second person, but you could designate them, instead of a second Title IX coordinator, you could designate them as an assistant Title IX coordinator, because you have to designate one person who is the coordinator. And if you have two coordinators, you still have to designate one person. So that's why in that portion, I went down to the option that says, the board designates Abigail Bohada.
What page is that on, Lori?
Well,
67.
I'm looking at the,
It's 13 pages in,
I like 39, right? I think right there, just go down a
14
little bit.
pages in.
Actually go up a
So
little.
keep, no, keep going,
Down or up?
down. Keep going down.
So we're getting
Nice
stuck in the weeds.
You gotta go up.
Page
You gotta go up.
37, I think.
How long are we spending on this? This is a waste of time.
There you go.
Oh, yeah, sorry. Yeah. You're right.
So Bruce, you said this doesn't apply to sports.
No.
So if there's no policy saying only biological females can be in a girls' basketball, how are you gonna stop that with this policy?
It's not addressed in this policy, Steve.
I don't
So
think
you would
I
need a
don't- I don't-
specific
but I know
policy.
What,
You would need a specific policy that says no biological males are allowed in female spaces or restrooms, correct?
let's
I,
continue.
we're not, so, again, I'm trying to get through this policy. That's what I'm trying to get through. I'm not trying to get any other questions. If anyone wants to get into the weeds on some other topic, you know, fine, if the board wants
We
to,
are
do it,
in
we
the
can,
weeds.
but.
We are in the weeds
No,
when
we're
we're
talking
talking
about a
about
policy
it.
on our agenda. That is our job as board members to go through policy.
Right.
And put policy in place. I'm
Yeah.
trying to get through this policy, and you keep pulling us off, veering us off away from what's actually in the policy.
I found
I'm
a
not-
paragraph. I found a paragraph from Viola. Do you want to hear it?
Yeah, okay, sure.
It's not in here, it was just under their, special detail.
Oh.
It says, the Title IX regulations continue by stating that adopting a policy or engaging in a practice that prevents a person from participating in an education program or activity consistent with the person's gender identity subjects a person to more than de minimis harm on the basis of sex. This latter language has direct implications for bathroom and locker room use.
Yes.
Okay.
Can you
Where's
tell me
that
where you
from?
had that?
Yeah, where is that from?
Yep, I can email it to you all.
That would be wonderful.
Okay, so I guess where I'm going with this is that is not what is going to be in our policy that we are reviewing.
This policy specifically addresses the procedures that will happen if someone files a complaint. That is all this policy does. If somebody files a complaint, these are the steps that we will take to address the complaint. That is what this policy is about. So,
But the problem is, if we vote yes on this
we're not
policy,
voting on anything
I
tonight.
understand
We are
that, but if we vote yes on
going
this
through
policy, we're violating a federal injunction.
And if we don't, we're also
We are not
breaking
violating it. We are not
the
breaking it.
law.
I don't believe
They're
that's
not voting.
settled yet, Steve.
Can I make a couple points?
Yes, thank you.
This is a policy. This is not Title IX.
Right,
This is how we're gonna follow it.
yep.
There is a federal injunction that applies to us via Trevor last week. Doesn't say we can't, it says the government, or the Department of Education can't hold us liable for anything if we don't change to this policy. We're perfectly fine keeping the 2266 we have and meeting state and federal law that exists now. If we wanted, I think you could dig into the weeds and find the protections you're looking for with all the additions that are in here. The biggest change is going to be how we approach complaints and the training that's going to be required. It's going to cost money. And the Title IX revisions, I believe, are unconstitutional, not because of any of the emotional things people are saying, it's because it was created by the Department of Education.
Yes.
And they don't have the authority to make or change federal law or regulation. Same thing came up with the EPA not long ago. They're there to enforce federal law and regulation. So that's why I think it's gonna end up being a non-issue down the road. So,
I agree, and I just want to remind, like, this is a prime example of, this isn't Title IX, this is our policy, how we interpret it. This is an opportunity for everyone listening and everyone living in where we live to get out and vote, because that is the only way. We can't change Title IX. The Title IX language is written, we can agree or disagree with it. It is what it is. We have an opportunity to change it. This is our policy, though.
so basically, we're fine tapping the brakes like it's been brought up.
We're fine, what?
Waiting.
The only thing that would change that is a successful appeal to that injunction. That we actually wouldn't be violating anything if we did adopt this policy. It just says that we don't have to. It's also dependent on Moms for Liberty putting the name of the district in with that judge today as a deadline. Did that happen or didn't it? I don't know. But we'll know before the next meeting.
I guess I just really struggle with legal advice from multiple sources, CISA, Neola, WASB, telling us continue to move forward with this policy. And added language in here that improves our existing policy. I don't know how this doesn't improve our existing policy.
I totally agree, but there's so much there that,
But what is
My
here, I
God.
guess, looking at the differences, what is here that you?
the biggest
you
change is going to be
want?
the training, the different training. It's gonna cost money that we may or may
We
not.
already do training.
Do we go through training?
We will need to be retrained. Mhm. Do we already do training? Yes, but this does require us to do a whole new set of training. Mhm.
Implementing the policy would it do that though?
For us?
That's another point. The policy is not gonna change anything for the better either. It's just,
The policy what? I couldn't hear you. The policy what?
policy alone won't change things. It's gonna be the policy as it relates to the changes in the law.
Well, I disagree because this policy affords the district more flexibility, as we spoke about at our last meeting, that it gives the opportunity, if both parties are agreeable, to go through a mediation process rather than the entire formal complaint process. That was one of the things. Also, that a complaint may be voted rather than written. It obligates the district to address any type of sexual discrimination, whether someone files a complaint or not. If the district becomes aware of a situation that is discriminatory with this new policy, we are required to address it without a complainant.
So you're talking
It
about.
also expands the district obligations to provide supportive measures to both parties involved. It includes the pregnancy issue that Bruce has already addressed. So there's a lot of things in this policy that are positive.
I'm totally
You say
willing-
these are positive? When you don't have due process and one person can make a decision?
I-
Appealed, Steve, we've gone through that.
Appeals, yeah.
I'm willing.
You're-
And it doesn't say shall, it says may.
You gotta understand, this has to do with kids, students' First Amendment rights and that of their parents.
So again, there's a First Amendment section in here, but again, that's,
The First Amendment's in the Constitution, it's not in there.
there is a section on the First Amendment in here.
Okay, that's fine, but the Constitution is the Constitution. When I took the oath up here, I was to defend the Constitution.
Yeah.
All right, so drafting note. Can you scroll down a little bit, please? Oh, sure, right there. That the board designates Abigail Bohada as a coordinator who was ultimately responsible for the oversight, and then filling in the name and all the other information for instead of saying second Title IX coordinator, an assistant Title IX coordinator, and then above the first one, put in the name and the other information as well, the email, the office, the telephone number. So Abby, did you agree, do you agree that's the best course to follow? Did you receive this ahead of time?
Yeah, yep.
Yeah.
I guess I'll do what the board decides to do.
Well, I asked, I
Yeah.
wanted your input. I was reading through the Neola recommendations, and that's the conclusion I came to, but I would like your input.
I think it's having the one person to go to for both sides, both families is used, more family friendly, because they would get communication from the coordinator, then the investigator, and they didn't really know who to ask the questions to. So I think that is more family friendly for both sides, to be able to have one contact person. Again, both ways work, so whatever you guys decide, that's how we would do it.
Well, this is just the part about listing who it is.
Mhm.
Okay. So then Bruce, was there another change that you wanted to highlight before there were other options?
I think there's some down in complaints section. Complaint is in where we have.
Are you under the grievance procedure heading?
Yes.
All right, so there's the overview. And then there's some options there that were taken that have to do with just the administrative guidelines, because we have those. And then the option, so this is under the heading of grievance procedures, under overview, 1, 2, and then 3, 4, 5, the 5th paragraph. Nothing herein shall prevent the Title IX coordinator from using a hybrid grievance procedure that contains aspects of the grievance procedures contained in both this policy and policy 2266, so that the parties receive all of the due process to which they are entitled. So that, again, is providing more flexibility. It's not required, but they may.
Where's the due process when maybe 2%, which would constitute a transgender student, decides to make accusations about a girl who's just using the restroom, and they come in exposing themselves? Where's the due process?
I don't understand what your question is. What does, a due process has to do with a complaint and
Right.
investigation?
No, I understand, but you can complain if you look at somebody sideways. You could be
A formal
tra-
complaint
A
would be.
formal complaint's not even in writing. You even said it's just oral. It could be oral.
Yeah,
Yeah.
but it would still be a formal complaint if it's brought to the Title
And that's a good thing, you think? You think
coordinator.
that's a good thing?
Do I think what's a good
But
thing?
it just has to be in oral and not in writing.
It would, yeah.
You think
I
that's
do.
good? Okay, great.
You know what, Steve, I thought about, that was one thing that went through my mind at the last. I look at, okay, for second, third grader, like, they're not gonna put in a formal written complaint. I think that's really that verbal.
The parents would, yeah.
If the parents, but I'm sorry, as a primary teacher, if a little first grader came to me and said, Mrs. Oster, so-and-so said this, I would hope that they could verbally say that, and as a teacher, I would run on that. Like, this isn't all, I mean, people aren't out I look at this at just a different, I agree with you, parents can put in formal. I think writing is great, but I think that verbally, I take that as our younger population. Because
Okay.
I can't see my second grader writing out a formal complaint.
So you talking about the transgender second grader or the one who's not transgender, or doesn't
I'm not
identify?
talking about transgender, I'm talking about harassment. I'm talking about, let's take trans out of this. This goes back to a boy and a girl. This is if you
I'm
wanna
talking
talk
about
about your
restrooms.
daughter.
I'm talking about restrooms.
I'm talking about this policy, because this is more than just restrooms.
We have an
If your
injunction.
daughter felt threatened by a male and verbally complained about that, I would hope that that's acted upon. I'm not talking about, there's a lot more to this than just a restroom.
They're afforded those.
And
rights.
right now, I'm gonna go back, you continue to say this business about you as a father and to different men, and frankly, I am sick, I feel harassed by you because I'm a woman.
Oh,
You've
that's,
done this since I started.
I see. Me Too movement, here we go. All right.
No, it's not that. This is how you start out. I'm not even
Excuse me.
disagreeing with you.
Excuse me. Our school district
Can we
since,
get back to the policy?
our school
please?
district since Dr. Donnelly has come on in 2022 has lost 24
Let's go
students.
on
All
with
right.
the
All right,
policy.
again, we're
We're
talking
on
about policy, let's
complaints.
continue to
Okay.
go on the policy.
So we're at the heading of
And you want to
complaints,
see a mass exodus, let's
and
keep going down this path.
we have a option of the administrative guidelines. And then there's the heading of basic requirements. And the decision maker and the appeal, all persons involved with implementing the grievance procedures and any other aspects, and the facilitator of the informal resolution process, because that is an option. That is, there can be an informal resolution process and not just the formal complaint process. Then there's another option that Neola recommended. And then there's a paragraph with some other ones. It has to do with, let me see if I can paraphrase so I don't have to read the whole thing. In circumstances when the Title IX coordinator and trained administrators do not have the time and/or capacity to serve or are prevented due to a conflict of interest, the Title IX coordinator and other trained administrators, the Title IX coordinator shall, in consultation and with the approval of the district administrator or board, it could have been any of those. So you have the option of the district administrator, the board, or the board president there. Do you see that paragraph?
Include the board first.
Yeah. And then in the evaluation underneath that, letter A, Neola recommended that it be the 10 days. And the same thing with the 30 days in letter B. And then the 5 days to respond to the evidence. All of those were Neola recommendations. And it's to be consistent with other policies that the board currently has dealing with discrimination. Letter C, the determination, 10 days there. There is the option that the 10-day deadline, unless the district administrator approves an extension of time, which must be communicated in writing to the parties. And then there's the part about the appeal, 5 days. And then you've got letter A again, and there's a Neola recommendation about only select, we don't, so that's why it's crossed out, because we crossed out the part about the designated confidential employees, because that was what Neola strongly recommended. Is there anything else in here, Bruce, that you had highlighted that was a difference from 2266?
I think right below this, once you start into dismissal of a complaint,
Okay.
there were some options to check.
Yep.
And Neil on, again, check option 1.
Yep.
Again, this is new to how to handle these complaints. These are new procedures to handle the complaints. This policy.
So option 1, did anybody have any questions about that? And then the next one had to do with an informal resolution process, which I referred to earlier as mediation. And Neola encourages the board to select the following option, so that's why that one was checked. Then there's the part about investigation. Was there anything in here, Bruce, that you wanted to highlight?
No.
Then there's the part about questioning the parties and witnesses.
They gave us option that we should either consult legal counsel if we needed to select things.
Yeah, so in the draft that I submitted, both of those options were eliminated and just keep the paragraph. If the investigator and decision maker are two separate individuals.
And then same thing goes into option again for the board to consult legal if they choose option 3, but Neola doesn't have an opinion for option 1 or 2. The section below.
And what I had checked in the part, in the document that was sent out to the board was option 2, the investigator will ask the relevant and not otherwise impermissible questions of the specific party or witness during one or more individual meetings, including follow-up meetings with the party or witness. Abby, did you have any opinions about this? Oh, you're good? Okay. After the parties have an opportunity to review the relevant and not otherwise impermissible evidence or an accurate description of this evidence, the decision maker, and they recommended not choosing 3 or 4. There was option 1 or 2. I was thinking 2, Abby, allow each party to propose or submit in writing relevant questions that they want asked of any party or witness, and the decision maker will ask the relevant and not otherwise impermissible questions of the specific party or witness during one or more individual meetings, including follow-up meetings with the party or witness.
Yep.
Did you have something that you thought would be better?
No, I'm just reading the first option, just looking at different options. That's one I would pick.
In my opinion, I thought option 2 provided the most flexibility.
Yep.
And then there's the heading about determination.
Pick the optional language for appeal of determination. For the 5 days again. We also checked option D, or not option, but just I would recommend remedies. Like,
That the party may appeal a determination if it are viewed as unreasonable. And then we have the guidelines for the appeal process. The Title IX coordinator will designate the district administrator to be the appeal decision maker, which was something that was recommended by Neola, and I think WASB talked about that as well, if I remember correctly. And then down below number 5, option 2. With the 5 days and the 10 days. Which was recommended.
By the time you get to the point here in this process, the parents will have pulled their kid from school.
And then the next part has to do with what the decision maker shall do. It was option 2. Then we're to the heading of supportive measures. We do have an employee assistance program, so that's why that option was checked.
There's another section that was added that we moved to this one as well.
Yeah, the
Policy.
supportive measures, which I think is another positive.
Right.
And then it goes into the heading of disciplinary sanctions and remedies for students.
A lot of these were included in the last one. I think we added in-school discipline and Saturday school to that first section. But all options were checked for students. Same with the next section, all this stuff was included. All these items were included through retaliation until you get to complaints. Record for confidentiality, there was some additional language added there. So, and then application of First Amendment.
So I'm not sure we have anything in our current board policies or the employee handbook. That's why there's a question mark for that option. Abby or Shannon, do you have any input on this? Because the sentence could be ended just right after the U.S. Constitution. Should we add the ending of the sentence?
I mean, probably a horse apiece, but sure. I mean, I'd be fine either way.
In any, it says in any board policy or employee handbook,
Mhm.
so I don't think it hurts to
Right.
check it.
No.
Okay, and the same with the second sentence?
Mhm.
All right.
The next is the training section, that was similar to the last one. Had the same training topic that if someone changes positions or there's a new person, they'll have to go through any of the Title IX training in this policy. Hire somebody new, we're gonna have someone go through that training anyway, which would be this year as well. Record keeping is the same, outside appointments, dual appointments, delegations, that's the same. Checking the box for discretion and application. And that's the same that we had before.
And that's it. Did anybody have any questions about?
Can you go back to that First Amendment piece? Did you say leave it all the way through employee handbook? Or end it?
Yes, no, to keep it.
Because that would, like, give me an example of that. So would that apply to flags or posters in a classroom?
The board will construe and apply this policy consistent with the First Amendment to the U.S. Constitution and the principles of academic freedom as set forth in any board policy or employee handbook.
Yeah, so like employee handbook, does that specify flags or posters or signs that a teacher would have up? Like I know we had the
Yeah.
Black Lives Matter flags and the
Mhm.
thin blue line flags. Does the handbook say you can't have any of those?
I have to double check.
Okay.
I know we ended up addressing it, I wasn't sitting in this chair at the time, I don't remember. So we can look. Bring it back.
All right, does anybody else have any thoughts or comments on this policy?
I got a couple comments. I looked at Danny's, that memo that she forwarded. Where did you get that from? Was that?
That was sent to us by Shannon.
From Neola, right? Yep.
Yeah, how, okay.
And I think you should be able to also see it, did you find it in the,
It was in the bundle you sent right off at the very beginning.
Yep.
of all this.
but also now you should be able, because I pulled it from board docs, that's what I was looking for. So you should be able to see it in there too, but,
So this specifically, I mean, it makes a mention, right? It's not, this isn't policy language, but there is this memo kind of highlights the differences, and it does identify sex-based harassment. Example, claims of unequal athletic opportunities, admissions, discrimination in courses or academic programs. And I know that is coming, and I just want to highlight it. That isn't in our policy, but this does concern me that if we adopt a new policy, do we bring some of that in kind of unknowingly?
Well,
I know it's coming, I know the athletic piece is coming, but it's not here, I didn't see it in this policy, but it does concern me.
and I hear you, and I think, and I'm fine discussing that when it comes, but I would go with what we know and what's in now.
Okay, the other thing I was going to say is, have we or can we get a clear opinion from WIAA on what is their opinion on sports teams as it stands either today or with this new policy in Wisconsin? I don't know who can speak to that from WIAA. I would like to know, because I know the specific language of Title IX says that if you have two different teams, if you have a boys and girls team, you don't have to allow, if someone says, I want to now join this team, we don't have to. That's clearly defined as it is now, and that wouldn't change with the new policy, but is WIAA going to change their stance on August 1st?
There's like a 90-page document on WIA that I was going through, because I've had the same, and the transgender piece of it is like kind of the same as they're saying, it's like kind of there's nothing now, but it's coming. But still, as we talked about the last, if there's not an equal sport at any time, if there's not an equal sport for a girl to join, she still, even if this was years ago, can join a male's team. If there's not an equal sport for them as of now.
so are you looking for, if WIAA has a current kind of right here and now, almost like a here's our position or our stance? Because they have clear guidelines they're using now, but are you looking for?
Well, yeah, I mean, I think they should, at this point, they should be able to tell us on August 1st, we're gonna have new guidelines.
That's what
Yeah,
I'm-
and if they don't, I'd like to know. If they do have guidelines that are coming, I'd like to know, because I would imagine they're drafted if they
Yeah,
exist.
yeah.
They don't govern our policies, though.
I know that, but there's still, we
Oh,
do
we're the-
fall back, I
yeah,
mean,
we're the
if there was a
member.
lawsuit, that's what the court's gonna fall back on. Again, it's not a policy, but if you look in general, you know, much like how the policy we currently have came to be, is because of what the Seventh Circuit identified. Whether we agree or not, that's the language they identified in case law, and now here we are. And again, we're like, we said it from the very beginning, we're kind of stuck with we're not ready Title IX. It is what it is. Whether we adopt the policy or not, it still exists, whether we agree with it or not. How do we as a board figure this out for our community? I think that's the most important piece. There is a piece to say like, hey, we don't discriminate, and if someone has a complaint, like by all means, I don't care what sex you are, I don't care what your background is, you should have a process to say, I feel discriminated, and you should know what the expectation is. I would agree with that. But there's a whole lot of stuff here.
So here's a problem. So if you read the ruling in Kansas, it's 47 pages, the judge explains everything very, very well, very carefully. So the Department of Education, these are the crazy things they're saying. Their lawyer said that a biological female who feels unsafe using the locker room or restroom could ask for an accommodation, such as using the staff restrooms. So in other words, the females have to leave and go to a staff restroom in this building or somewhere else, but yet the transgender student can have full right and full access to the female restroom. That's discrimination, exactly. There's just so many problems with this, and we get an injunction, and here we are spending how much time on this when we don't need to. I'd like to talk about the budget, I'd like to talk about SROs, I'd like to talk about what we're going to do for academic excellence, declining enrollment, which costs us a lot of money.
I believe the next policy then that we're going to review is 1230.01.
Starting back at the
Beginning.
Okay. Start at the top then.
And really, everyone was supposed to read these before coming, so we shouldn't have to go through every policy. We should just be able to say 1230.01, development of administrative guidelines. Does anybody have a question on what the policy committee recommended? Does anybody? Nope. Okay, next one. 3140, non-renewal resignation and termination. The policy committee recommended that we not take this one because this information is included in our employee handbook.
So it's not necessary.
Correct. And the same thing with 5605. These are addressed in our student handbooks.
So again, not necessary.
Correct. 2120, management restructuring and school improvement. Policy committee recommended not taking this one. And editing, because it's mentioned in policy 2605, and the policy committee went through that. Alicia has those notes, so we can just end the sentence before that policy is mentioned. The next one is 6152, student fees, fines, and charges. The policy committee recommended taking this one. Note that DPI guidance is, well, did anybody have a question on it? If not, the next one is 4124, letter of reasonable assurance. It's very, we do this already, and we recommended having it. 4162, controlled substance and alcohol policy for employees that transport students. The policy committee recommended taking this. Did anybody have any questions on this one? The next one, 9211, district support organizations. I think that's supposed to be district supported organizations. I think there's just a typo there. Did anybody have a question on this policy? 9140, citizens advisory committees.
What was your recommendation on that?
To take the policy. Did you have any question on it?
No, but if I read that right, there has to be parents on that, correct?
We may establish citizens advisory committees. And I mean, the language is very clear. It depends on the committee and what the board decides about a particular committee.
Okay.
It wouldn't necessarily be the same every time.
How, what was the policy that you brought up a few months ago? That was 9140?
Yeah.
Okay.
The next one is 8452, automated external defibrillators. Anybody have any questions on this one? Policy 3120.04, employment of substitutes. The policy committee recommended not taking this because it's addressed in our other areas. Policy 6152.01, waiver of school fees or fines. We recommended that this one be adopted. Did anybody have any questions about this one? Yep.
I didn't.
Oh. Then policy 0167.3, public comment at board meetings. It was asked at a previous meeting to include the Neola template of this so that we could compare our current policy to the template.
Are there any new restrictions on public comment with this policy?
This is what we currently have.
Okay.
Hey, I wanted, so you said we currently have our active policy was in orange,
Uh-huh.
but isn't like that first section included already? That's not highlighted in orange?
No. Because that is included elsewhere.
Oh. Oh, yeah, it's not.
Is the policy committee's opinions included in this?
There
Or
is
is it just
this-
that-
There is no,
Did you guys have discussion?
this was not a policy that Neola was bringing back for updates.
Oh, got it.
This policy has been on our agenda, this is the fourth agenda, and it has to do with letter B, anyone having a legitimate interest in the actions of the board. And in previous years, it was the board's agreement that a legitimate interest in the actions of the board meant that you are a taxpayer in the district, you have a child enrolled in the district, or you're a staff member in the district. That would be a legitimate interest in the actions of the board. There is no state law governing this. It is completely up to each board to decide for itself what a legitimate interest in the actions of the board means. So we can decide as a board who has a legitimate interest in the actions of the board. And it's my personal opinion that it should be the same definition that we abided by in the past, that it is a taxpayer in the district, a parent who has a child enrolled in the district, or a staff member in the district.
So how does that work when we had Rudy Perez, the National Director of the School Resource Officers Organization, come in and give us information? And he gave public comment beforehand.
So if a outside group is invited and included on the agenda to provide information to the board at the board's request, that is by all means acceptable. But no, he would not be allowed to give a public comment.
And I actually would agree, because Rudy, when he gave his public comment, right, we're not supposed to interact, ask questions. It would have been nice to actually have a open dialogue with them, which we did later, but, yeah, I don't know if that's appropriate. Even like your phone call, maybe an agenda item instead, rather than public comment, because they get cut off. If there's value to the agenda and they don't live here, then the only problem is, and I think that the board president and vice have to decide that. That would be the only thing, is who makes it on the agenda and who doesn't.
I mean, but that's also, you know, when we talk about two people can request a topic on the agenda. And,
A topic,
right, but if we want to have someone else.
that would be a board decision or the people, I think it's in our policy currently that our district administrator, together with our board president, sets the agenda. So the district administrator and the board president set the agenda. A topic can be included, but not necessarily an outside speaker. I mean, that would be the decision of the district administrator and the board president.
Yes.
If the topic is included and we have a board discussion and a board vote on it, then it would be the majority vote of the board.
Do you think this has been an issue where we need to restrict our public comment?
To people who pay taxes and live in the district and have children enrolled in the
Those are the only
district,
ones that can speak, is what you're saying.
they have a legitimate interest in
Okay.
the,
So what about
actions of the
a
board.
assembly candidate?
School board is not a political affiliation. It is, I do not personally think it's appropriate, and if they don't live in the district, they shouldn't be making public comments at our board meeting.
Okay, that's your opinion.
Yeah, and that's why it's a board decision, a
I think
total
the more
board decision.
public comment, the better, if somebody's, right? Why are we putting limitations on comments? Has it been such an issue in the past? Is perhaps Moms for Liberty the problem?
Moms for Liberty,
Would be able to speak.
if they live in the district.
Okay, so why is this an issue? I'm just asking.
I think she's spoke her opinion, I mean, that she spoke her opinion, that's it.
It's a
You can
board
disagree.
decision.
Yeah.
In my opinion, a legitimate interest in the district and in it was agreed by previous boards that a legitimate interest in the district is a taxpayer in the district, a parent who has a child enrolled in the district, or a staff member in the district. So the board needs to have a discussion about this and make a decision.
I received a lot of, I think all of us received a lot of emails pertaining to this topic as well. I did like one community member had suggested not necessarily limiting, but if you have, and I know this came up at the last meeting, if we go, because right now in our policy, it states that if it's over 20 minutes, we vote on that as a board to allow everybody, but if there is more than 20 minutes, then we choose to limit the speakers to what you're saying, to a taxpayer, child enrolled in a district, or staff. I mean, other times I feel like, when there are big decisions, I think it is important to hear from people that are vested, that have their kids here, that are taxpayers. But I think there's also those meetings where, okay, there's no, we don't have a line out the door. I mean, I don't think it hurts anything to hear from people that aren't. I don't know. I liked that. I personally liked that idea of that.
So does somebody draft language, propose language, how do we,
Well, I guess
what's next?
it's up to us to say, what does legitimate interest mean? Like, what does that language mean to this board? Is it what Lori's stating, or, do we add that language like she's saying? Is that something that the board wants to add? That unless you're a taxpayer, an employee, or parent of a student in the district?
So the only language that would need to be included in the policy is in letter B, anyone having a legitimate interest in the actions of the board, and then in parentheses, a taxpayer in the district, a parent with a child enrolled in the district, or a staff member of the district. That would be the language.
Any thoughts on that one?
What a grandparent. How do
You
you-
said that the last one.
And in our policies, a grandparent or a guardian or they are, if they're in the position of a parent, they are included in our policies, that's in our definitions, in our bylaws. If they are not the guardian of the child, then they might be a taxpayer in the district,
What if they aren't?
well, then they wouldn't
Okay.
have a
So
legitimate
this is the
interest.
problem with limiting public comment. Pretty soon you're trapped because, well, yeah, we can't let you speak, I'm sorry. Sounds like a legitimate issue. Just don't understand.
If it's a legitimate interest, why would a grandparent who doesn't live in the district be there speaking about it and not the parent?
Like,
It could happen.
absolutely.
I like keeping it broad.
I'm gonna go back to the other suggestion that I got, that if it's beyond time, not limited every time, but if it's beyond the 20 minutes, then we prioritize people that are taxpayers, parents or staff.
Yeah, I would agree with her. It's very rare that this place is full for public comment, but I think on, if someone's here, if, this is nonpartisan, but if there's a candidate that wants to come speak and there's no one else here, I'll listen. I think it's fair. But if you know, if there's 20 minutes, then the 20 minutes gets priority to those that live here. And I think identifying, you know, the student of the district, a taxpayer, I think that's a good start.
So then, like, last week we had like 9 or 10 inter-district, and we said, yes, let's extend the time. So then we also had another 6 or 7 more. And we had a small discussion, would we extend it to include them as well, or do we cut that off?
I think you'd cut it off. If they don't live here, you give priority to those that do, or have kids here. And you cut it off. But if someone comes here from out of our district and wants to speak on something, and there's no one else here, or there's 10 minutes, then sure, let them talk.
I think the other thing, this is, the thought as I had saw that, like right now, you know, we kind of mentioned, if there is somebody, I think even in the county that's really concerned, or maybe lives in New Richmond or Hudson, I mean, New Richmond and Hudson have their public comment and forums at their board meetings as well.
And they only allow residents of the district.
And resident, okay.
I guess, and that's what I'm wondering, like, if it's if you're coming to our board meeting, why are you coming to ours and not your own?
Where you live, where you're
board
paying
meeting?
taxes.
Yeah, where you have decision on who can be in those positions, or directly impacts your kids or your livelihood, I guess.
My other question is, does this still give flexibility to say, we can do 40 minutes? Or are we limited on 20? Because we'd have to say, if we're gonna say 20 minutes, then either gotta cut everybody off or extend it.
We
But if
have
you're
to
gonna-
amend that if we're gonna do it.
But if you extend it to just the legitimate interest,
That's what I
I
was
think that's
asking
why
right
you
away.
have to put in the wording.
then I would be okay with that. It allows,
Would you be okay
it
with
allows people to come speak if they don't live here, but if there's a lot of people here, then it gives us the ability to say, you gotta live here to talk. And we'll go over 20 minutes, but you gotta live here or have kids.
So it wouldn't be any added language, it'd just be part of the motion.
The added language would be at the end of letter B, anyone having a legitimate interest may comment during the public portion of a meeting unless the public portion of, public comment portion of the meeting will go beyond 20 minutes.
All right, I guess it'd be time limited, yeah. Okay.
In which case, those who are not taxpayers,
I would not put it as a negative. I would put it as in which someone who is a taxpayer.
Those who are taxpayers, parents, or staff in the district will be given priority, and those who are not will not be allowed additional time.
So you have a parameter of 20 minutes, that's it?
No, it can be extended.
That's our
I'll
current
just leave it
policy.
at priority.
Will be given priority.
That's what, the 20 minutes has
And you
been
can define
out
it.
I
forever.
think every meeting that it's been over 20 minutes, we've said we'll allow those people to speak. I've never been at one where we haven't.
Because item 5 still says you can waive the rules,
Yeah.
right?
Yep.
So
But
regardless,
that's-
you could
so-
say,
So would we continue then with saying how people are from, you know, Hudson, we'd say, yep, even though we're over 20 minutes, we're gonna extend it, and we're gonna include anybody who wants to make a comment?
well, I think it says you have the ability as the president to waive them if you want.
No, it's by board vote, unless extended by a board vote.
Yeah, then we vote. Did you update that?
I typed it in as a comment.
Oh, okay.
You should be able to see it on the document now.
I'm not looking at the
Okay.
Google, I'm just looking at the PDF. Okay.
And again, we're not voting on this tonight, so, I'm just coming up with this language right here, so I'm gonna reserve the right to come up with better language, and it'll be presented at the next meeting if it needs to be fixed.
Along with the original, if we want to keep with that.
Sure.
Yeah, we don't have to make any changes to it. Any other comments on the public comment topic? Policy. Okay.
The next policy here is 2605, program accountability and evaluation. Any questions on that one? Policy 7542, on-site access to district technology resources. We asked our IT people for input on this one, and you can see those options marked, and the IT department filled in. Did anybody have any questions on this one? All right, and then that was the end of the policies that were brought forward by Neola for update.
Okay. And I will take a motion to adjourn.
So moved.
Is there a second?
I'll second that.
All those in favor?
Aye.
All right. Thanks, everybody.